Good morning and welcome to this meeting of the Court Reporters Board. I have a few housekeeping matters to share before I call the meeting to order, beginning with a reminder to everyone that this meeting is being recorded and webcast. Today's meeting will be run in accordance with the Open Meeting Act as required by law. I would ask all of us to please turn our cell phones to silent. You may notice board members accessing their laptops, phones, or other devices during the meeting. They are using the devices solely to access the board meeting materials that are in electronic format. The board welcomes public comment on any item on the agenda, and it is the board's intent to ask for public comment prior to the board taking action on any agenda item. If for any reason I forget to ask the public comment on an agenda item and you wish to speak on that item, raise your hand and you will be recognized. To better assist the board in accurately transcribing the minutes of the meeting, members of the public who make a comment may be asked to disclose their name and association. However, disclosure of that information is not required by law and is purely voluntary. I want to remind all speakers to please stay on topic and keep your comments to 3 minutes or less. If you agree with the prior speaker, please do not repeat the comments, but rather state that you agree with comments already made. I would like to actually back up and say good morning and welcome to our March board meeting of the California Court Reporters Board. I would like to call the meeting to order and ask that Ms. Bruning please call the roll.
My apologies for the delay. Ms. Hurt?
Hurt present.
Thank you. Ms. Brewer?
Brewer present.
Mr. Manayan?
Present.
Ms. Chagade?
Chagade present.
Ms. Sunkis?
Present.
Thank you. Quorum reached.
Thank you, Ms. Bruning. Initially, I'd like to introduce and welcome Helen Joffrey, our new board counsel from the Department of Consumer Affairs. Good morning, Helen, and welcome.
Thank you. Thank you very much. I appreciate it.
Absolutely. Our first agenda item is number 1, public comments for items not on the agenda. Before we invite speakers to begin, I would ask individuals making comments to not discuss pending complaints, pending applications, or pending disciplinary actions that may come before the board for a decision. Such discussions are considered ex parte communications as they could provide information to the board members that is outside of the record, which is in violation of the Administrative Procedure Act. Therefore, such discussions could create a conflict and lead to a board decision being challenged in Superior Court. The board can receive comments regarding the board's processes in general, but it cannot receive comments on specific case circumstances where the decision is still pending. Board staff is available to speak with you about any pending matter. In addition, the board would ask that the public address the board as a whole and not individual board members. Please be aware that public comment during this meeting, during this agenda item, should provide information to the board members and is not a discussion between board members and the public. The only action board members can take is to listen to comments and decide whether they want a future agenda item on the topic. No other action can be taken on the item at this meeting. Though this may seem at times like the board members are not being responsive, following these guidelines is critical to ensure the rules of the Open Meeting Act are followed to avoid compromising the speaker's goals or the board's mission. With that, is there anyone wishing to offer public comment?
This is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of the WebEx screen or use the raise hand function. And audio-only participants can raise their hand by pressing *3 on their device. And it looks like we do have a request for public comment from Priscilla Gwaltney. And Priscilla, you will be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device. All right, and you are unmuted.
Okay, can you hear me?
Yes, we can hear you.
Okay, great. Yes, this is Priscilla Gwaltney with CCRA. I'd like to add something to the agenda. I'd like the CRB to consider reciprocity with both the NVRA and NCRA.
Thank you. I've made a note of that.
Thank you.
All right, and this is the moderator. It appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, please.
Madam Chair, this is Yvonne. I just wanted to let Ms. Gwaltney know that the reciprocity with MVRA is on today's agenda. And if she's interested in that, then she can, if she has time, the board will be discussing that today.
Thank you, Ms. Fenner, for pointing that out. So we'll move on to agenda item number 2, which is approval of the December 14, 2022 meeting minutes. Are there any other additions or corrections to the minutes from the board members? Seeing no hands, may I have a motion to approve these as submitted?
Motion to approve.
Thank
Second.
you. Thank you. Was that Ms. Hurt on the second?
Yes.
Thank you. I thought. So it's been moved by Mr. Manayan and seconded by Ms. Hurt. Is there anyone from the public who wishes to comment on the minutes?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And audio-only participants can raise their hand by pressing *3 on their device. And it appears at this moment there are no requests for public comment. Would you like me to close that Q&A panel?
Yes, please. And I failed to say what the motion moved and seconded was to approve the meeting minutes of December 14, 2022. Ms. Bruning, would you please call the roll on the vote on this item?
Yes, thank you. Ms. Brewer?
Yes.
Ms. Hurt?
Aye.
Mr. Manayan?
Yes.
Ms. Chagade?
Aye.
Ms. Sunkis?
Yes.
Motion carries.
Thank you. Turning to agenda item number 3, our update from the Department of Consumer Affairs. I would like to welcome Judy Bucciarelli, a representative from the Board and Bureau Relations, who will be presenting the board update. The board with an update. Good morning, Ms. Bucciarelli.
I'm seeing her microphone is still muted.
Should we perhaps move on to agenda item 4 and come back to agenda item 3? There she is.
Can you hear me now? I'm sorry about that. The box didn't pop up for me, so it just did.
No worries at all. Good morning,
Good morning.
and welcome.
Thank you.
Would you like to give your report?
Yes, I'll do that now. Thank you. Well, good morning, and thank you for allowing me the opportunity to provide the Department of Consumer Affairs update today. At the end of January, the Diversity, Equity, and Inclusion Steering Committee, which I'll refer to as DEI, met and decided to focus on training in the first quarter of 2023. Over the next few months, all staff, including DCA's solid trainers and board and bureau leadership, will receive DEI training, and regular and recurring training opportunities will be available. On March 3rd, DCA's Solid Planning and Training Unit led a full day of training for the committee. The training included 4 training modules, which were understanding the value of DEI in the workplace, learning to navigate diverse conversations, decoding our unconscious biases, unleashing the power of generational differences. On March 22nd, as part of the director's quarterly meeting, executive officers and bureau chiefs attended a 1.5-hour DEI leadership training to gain a general understanding of diversity, equity, and inclusion and what it means as a leader and regulator within DCA. In late April, solid trainers will be DEI certified and offer DEI-related trainings to all DCA employees by June of this year. The DEI Steering Committee will meet again on May 12th. Equally important, the DCA Solids team is in the final stages of updating its strategic planning process, which includes an equity analysis. Environmental scan surveys and SWOT analyses will include DEI-related questions to assist boards and bureaus in developing DEI-related goals and objectives as part of their strategic plans. To further assist the boards and bureaus, sample DEI objectives will be provided. A training video, as well as video messages from Business, Consumer Services, and Housing Agency Secretary Lourdes Castro Ramirez and DCA Director Kimberly Kirchmeyer, are in the works to explain their perspectives on DEI and how it relates to the board's roles as regulators and policymakers. To improve public access, DCA is creating a centralized website page on DCA's website that will house all board and bureau strategic plans. Once these new DEI components have been finalized, Solid will begin working with the boards and bureaus to develop new strategic plans or update existing ones. As new information becomes available, we will keep your executive officer informed. As a reminder, now is a great time to review all of the necessary board member trainings and submit your certificates of completion to your executive officer and to DCA at memberrelations@dca.ca.gov. There are 2 DCA-wide mandatory trainings for 2023. This includes sexual harassment prevention training and information security awareness. All DCA employees and appointees, including board members, will need to complete the sexual harassment prevention training this year. This training is required every odd-numbered year, taken online, and is self-paced. The training takes approximately 2 hours. Please note that if you are assigned a DCA email, you are required to complete the Information Security Awareness Fundamentals 2023 training. Information Security Awareness training addresses everyone's role in protecting DCA data and information. The training is online and required every year. Both the Sexual Harassment Prevention Training and Information Security Awareness Training are available in the department's Learning Management System, which we commonly refer to as LMS. Both trainings can be accessed online at any time. In the next few weeks, board members will receive information via email on how to access these trainings. In addition, board members must complete board member orientation training, also referred to as BMOT, within the first year of appointment or reappointment, ethics training within 6 months of appointment and every 2 years thereafter, and defensive driver training within the first year and every 4 years thereafter. For your convenience, these trainings are offered multiple times a year in a variety of formats. For more information, a mandatory trainings page has been created to help members identify, access, and track specified trainings. This page includes direct links to mandatory trainings as well as pertinent information and policies specific to these training courses. You may go to dca.ca.gov and click on the DCA Board Member Resource Center page under Required Board Member Training. You may also reach out to Melissa Gear or Yvonne Durantes for assistance. The department would like to remind you that annual Form 700s were due on March 15, 2023. Board and committee members are required to file a Statement of Economic Interest, Form 700, within 30 days of their appointment, annually and within 30 days of leaving office. This year's annual filing period covers the prior calendar year, January 1 through December 31st, 2022. The official deadline for filing is Friday, April 1st, 2023. To ensure compliance, DCA requested that Form 700 filers complete e-filing by Friday, March 15, 2023. Members should have recently received an email from NetFile with instructions on how to file your annual Form 700. If you have any questions or would like more information, please contact Board and Bureau Relations Chief Deputy Melissa Gear. Board Member Orientation Training. As previously mentioned, board members must complete BMOT within 1 year of their appointment or reappointment. I needed to update this. Actually, BMOT was offered as a live virtual day of training last week. The next 2 trainings are scheduled for June 20th and October 10th and may be held in person. Members can register for this training online via LMS. Virtual meetings and BagleyKeen Open Meeting Act. As most of you know, legislation passed last year that amended provisions of the BagleyKeen Open Meeting Act to extend the ability of state bodies such as DCA's boards and bureaus to conduct public meetings virtually through July 1, 2023. Under the current provisions, no physical meeting location is necessary. Board members' virtual locations do not need to be open to the public, and members of the public can participate virtually or by telephone, increasing accessibility. Absent legislation to extend these provisions, DCA's boards and bureaus will not be allowed to conduct meetings virtually. After July 1, boards will have to return to the Open Meeting Act teleconference meeting requirements they were accustomed to before the COVID-19 emergency. In case you missed it, Board and Bureau Relations circulated its winter board member newsletter at the end of January. This issue includes an introduction of the BBR team, helpful resources, training details, and department updates. Please visit dca.ca.gov to check it out. Lastly, I would like to let members know that DCA has begun its Enlightened enforcement project. You may remember that last year, the Enlightened licensing project team released its report, including recommendations on how to improve the licensing process, specifically for the Board of Registered Nursing, but there were many recommendations that other boards could implement to improve their processes. This month, the team is now moving to enforcement, and the Dental Board of California has agreed to be the first board to go through this process. On March 2nd, the co-chairs on this project led staff through a review of their complaint and investigation process, as subject matter experts from all of the boards were able to ask questions and provide suggestions. This review process will continue until all aspects of the enforcement process have been reviewed. The end result will be another report with recommendations, a sample enforcement policies and procedures manual, and a critical review of the process that will be used to update DCA's Enforcement Academy training. This process will also assist in identifying codes used for reporting to ensure all boards and bureaus are reporting their data accurately. The DCA and BBR team look forward to working with you and assisting you throughout the year. We are here to support you and the important work that you do. Please reach out to us anytime. To conclude, I'd like to thank you again for this opportunity. And at this time, I'll turn it back over to the board president, and I welcome any questions from the board.
Thank you for that update, Ms. Bucciarelli.
Thank you. You're welcome.
So with that, we'll move on to our next agenda item, number 4, the report from our executive officer.
I apologize, but could we please get public comment on the last item? Public comment is required on every agenda item.
Well, then we'll ask for public comment. Is there any public comment on the report from the Department of Consumer Affairs?
This is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And audio-only participants can raise their hand by pressing *3 on their device. And it appears there are no requests for public comment. Would you like me to close that Q&A panel?
Yes, please. Were there any members of the board that had a comment on the report that was given? I am seeing no hands, so now I'll move on to agenda item 4, which is the report from our executive officer. Ms. Fenner, what do you have for us?
Thank you, Chair Sunkeys. I'll start off my report with a review of the budget. If you want to look at page 16 of the board meeting materials, we have the expenditure projections for fiscal month 7. You will see that through the continued efforts of staff to keep expenditures minimal and the savings that we are continuing to realize by holding the board meetings remotely, we are in sound fiscal shape and in a good position to support our technology modernization efforts. Are there any questions on the expenditure projections?
Ms. Hurt, I see a hand raised.
Yeah, actually, it's just a quick question that came to mind when you spoke to the fact that we do have remote meetings. When that would change? In other words, when we should expect those expenditures to get added to our budget report.
There is a bill that was introduced. It was too late for our packet that would expand that. So we're watching that bill to find out if we'll be required to meet once a year in person or if we will be able to do it all remotely. But right now, I think the current legislation is through June, but I could be wrong on that. I know it was through this meeting, but we're watching the bill that would extend our ability to meet remotely.
Okay, thank you. And I just wanted to add that not only are we meeting remotely, but we have had our online testing, which has also actually helped a lot with our fund or our balance. And over the years, we've tightened our belts quite a bit to streamline many areas. So kudos to the board and thank you, Ms. Finner.
Thank you, Board Member Hurt. Moving on to page 17, you'll find the overall fund condition. if we go down to our months in reserve, you'll see that we are looking very stable at around 9 to 10 months. And I'm happy to answer any questions on the overall fund condition if anyone has any.
I am seeing no hands.
Okay. If there aren't any questions, then I'll ask Ms. Bruning to please update you on the transcript reimbursement fund.
Good morning, board. So before I give my usual statistics, I'd like to offer some information on the background and application processes, just for some perspective. As you may recall, there are two pathways for access to the transcript reimbursement fund. The first, that was established in 1981, it assists nonprofit legal entities with transcript costs for their pro bono clients. These applications are generally pretty straightforward. The most helpful aspect being that most of the nonprofits submit applications on a regular basis, and so they have the process pretty well down. Additionally, the majority of these applications are for deposition transcripts, and they're accompanied by an invoice because the transcripts have already been produced. So once we've completed our review and processed the invoice, we're done with that application. On the other side is the establishment in 2011 of the Pro-Per program, and that's to help self-represented indigent litigants with their transcript costs. And although the application is relatively straightforward, there's an unfortunate number of applications that are deficient. They're missing necessary information such as the date of the hearing, the name of the court reporter, the estimate or invoice, and the required fee waiver. This results in heavy delays in the process. We end up emailing the litigant requesting the information that's missing so that we can complete the application. And the consequences of this, of course, are multiple emails and phone calls, which again weigh down the process. So when one of those Pro-Per applications is complete and accompanied with all the required documentation, we usually are able to provisionally approve the application since the litigant has not yet paid for their desired transcript. A letter goes to the litigant with a copy to each of the involved court reporters outlining which dates are to be produced and, of course, the coordinating estimate for those dates. Later, the court reporter sends their invoice that we review and approve for payment. So as you can see, there's yet another step in the process. So I'd like to give you some statistics. Well, first, would any board members have any questions so far? Ms. Brewer?
Yes, thank you, Paula. I do have a question about this staff-heavy application process for the Pro-Per, and I'm just wondering if you've been able to, if there's any, it sounds like there might be some similarities in the deficiencies that people have in their application, and I've wondered if you've been able to do anything to alter the application or provide more information up front to help with that so that it cuts back on staff time on the back end. Thank you.
When we reopened the program in November of 2020, we did review our application and our guidelines with the assistance of the Office of Public Affairs. We simplified it the best we can. There is necessary information. The unfortunate part is that these are Pro-Per litigants who just aren't used to the process of contacting court reporters, finding out, who that person was, what their estimate was. Every county has a different website, so navigating it is a case-by-case basis, which I've become somewhat familiar with the major ones because we work with them a lot. But I think it's just kind of nature of the beast that these are people who would normally never encounter these types of things in their normal daily lives. I believe that the explanation, we have 2 pages of guidelines in front of every application, explain exactly what we need and why. Sometimes wonder if they just aren't interested in reading that or something to that effect, but we have made it as simple as we can. We are working with the Modernization project to hopefully make this application online, fillable, submittable all online to streamline the process. But that is going to, of course, be a while. I have standard language in emails that I copy and paste, things like that. Does that answer your question?
Yes, thank you so much. It'll be very nice to see when that's online. That'll be great. And I have another question about this fund later.
Okay.
I see Miss Board Member Hurd has her hand up as well.
Thank you, Chair. So just a quick question. On average, how long is it taking to process these transcripts, reimbursement?
I can tell you that our processing time has been longer than desired over the last several months. We were recently able to reduce their initial review time to a 30-day window. There's a lot of different factors that play into that, my workload does vary because it's not just the transcript reimbursement fund, as you're aware. So, and then the number of applications, we could receive 10 in one day, and then maybe a couple days go by before we receive one. So that, of course, impacts the time frame for the review process.
Do we need another half-time person, or is there a plan afoot to try to work on the time it takes with all the factors and circumstances you've talked about?
Yeah, so recently I've been working with our half-time receptionist to get her started on the training for the initial review. There's a lot of different aspects of this program that you need to be trained on, and just a lot of it's experience case by case. So that'll take a while, but that'll help alleviate some of the pressure as well.
Okay, and I highly support online applications. I think it gets people to sit down and really focus, and you don't have the back and forth of emails. So I look forward to that completion as well. And maybe a suggestion too is, I don't know how fancy we can get, but sometimes people are visual learners. And so if we could do a video on how to go through the process and have it on our website, that would be an interesting support.
I'm glad you said that, because that is on my dream list as well, to do like a PowerPoint, maybe a interactive, well, not necessarily just a PowerPoint, but something with, an explanation behind it and some additional assistance with navigating the court's websites and how to contact court reporters.
Great. Those are all my questions. Thank you.
Okay, so then yes, Ms. Brewer.
Ms. Bruning, thanks. I just, because of your last comment and what you had previously said about all the courts' sites differing, is there any guidance that we can give to the courts to try to encourage them to have a similar site? I mean, I don't know if that makes any difference because each applicant is going to be different, but that was one question. And then I had another question just about the funding, and I don't know if this would be an appropriate time to ask.
So to address your first question, I mean, we're dealing with more than 50 counties who all have their own websites, and I'm sure their own teams of people who decide what's going to go on those. I can make suggestions. I don't know how well they'll be heard, or if at all. So yeah, I don't know how to really answer you on that because of the variety of different jurisdictions we're dealing with. You had a question about funding as well.
Yes, and I apologize if my knowledge is just deficient and this has already happened, but
not at all.
In reading through the through the previous sunset review, I think it was, there was a lot of discussion about the funding limit and the calendar year versus fiscal year for the two different TRF funds. And I'm just wondering, have we overcome that barrier of the calendar year versus the fiscal year so that we can provide a boost in funding partway through the year? And I'm wondering if that's happened and if that's helped.
Yes, during our last sunset review, when the legislature made its changes to our law, our Business and Professions Code that governs the transcript reimbursement fund, they did align the programs both into fiscal year. So we're no longer dealing with the calendar year aspect for the pro-per program. Additionally, there used to be a cap originally of $30,000 per fiscal, or excuse me, per calendar year for all pro-per applicants cases. And then it was later updated to $75,000, but during the last sunset process, that was dismissed and the pro-pers were integrated into the main fund. So even though there's a cap per case of $2,500, there's no longer a cap on the number of pro-per applications that we can assist in a fiscal year. It would just be lumped in with the pro bonos with any restrictions we have on funding, which of course our program is currently very well funded. Thank you to the legislature for their $500,000 bonus, if you will, last year, or I believe it was in the budget trailer from the last fiscal year for this fiscal year.
Thank you. That's fantastic.
I would just like to give you some comparative statistics for this fiscal year so far. We have paid out over $115,000 for pro bono applications. We have provisionally approved 2 applications, which are pending $708 in invoices. Comparatively, for the pro-per program, we have provisionally approved over 200 applications. Well, we have approved over 200 applications, but currently 113 of those are awaiting invoices, totaling close to $40,000. We've paid over $35,000 in invoices for the pro-per program. So altogether, that is more than $75,000. For pending applications for the pro bono program, I currently have 24 pending with 16 deficient. So there are 8 left to review. But with the pro-pers, we have over 90 applications pending. We only have 11 of those yet to be reviewed and 80 are deficient. So therefore, this goes back to my explanation on the process and the delays. So we are required to process them in the order they are received. So we do review them in the order they are received. However, once I've determined whether they are a go or a stop, we move on to the next application. That's all the information I have prepared for this presentation, but again, I'm happy to answer questions.
I'm seeing no more hands.
Okay, thank you.
Thanks, Ms. Bruning.
I would really like to thank Ms. Bruning deeply for all of the hard work that she's done on administering this program. As you all know, it was split between 2 people. She's handling it all in addition to all of the other duties that she takes on in the office. So she's had her hands full and is a real trooper. And I want to just shout out, thank you so much. Moving on to the enforcement statistics, you can see the statistics are for the period of July 1st, 2022 through February 28th, 2023. And they appear on pages 19 and 20 of the board materials that were supplied. The data that you see includes complaints against licensees as well as firms. I can tell you there are no new trends to report, and I'm happy to answer any questions that you have.
I'm not seeing any hands raised.
Okay, then we will move on to our license exam statistics. We begin with the dictation exam statistics that are on page 21 of the board agenda packet. And just to update you on the current cycle that just ended, We had 100 candidates apply to take the exam. That testing cycle opened March 1st and ended March 22nd, with yesterday open for retests. Of the 191 actually took the test, and of that 91, 29 were first timers. I would just have a huge shout out, hopefully, to anybody that's involved with the schools or with the students. I would strongly encourage candidates to schedule early in the exam cycle. We had 50 people, so over half of the candidates that took the test waited to schedule until the last 3 days of the exam. If they had any issues with the exam, it doesn't give them time for a retest because they need 72 hours advance notice to schedule a proctor. So we can't stress how important it is not to wait until the last minute to schedule your exam test. And then I am really excited to report that last week, we licensed our first voice writer here in California. So this has been a long time coming and exciting news. And I would ask if there are any questions specific to the skills exam.
Ms. Hurt, I see your hand raised.
Thanks. I thank you, Chair. I continue to be concerned with the number of individuals that are taking the tests. And I'm just wondering, Ms. Finner, through kind of your professional expertise, what do you see in the future with these numbers, and what should we be doing as a board more? I know we have a mission that's stated, and it's not necessarily to get people to the test. Just curious what you're thinking as you look at these numbers from 2008 to 2022 and how they've just continued to decrease.
I think that part of it will be a market correction. As word of the shortage gets out, then we generally see an uptick in the number of people that apply to court reporting because the word is kind of out. I think the other thing that will really help on a more short-term basis is allowing the voice writers. So I know that more than one school is adding voice writing as part of their curriculum. I think because that is a shorter program, I would expect these numbers to improve, but we do need that initial training time.
Thanks. It's one of the reasons, since being on this board, working really hard to make sure that we got voice writers on board, and just wondering, I guess we'll talk more during our strategic planning, what more we can do on our end to help bolster through our mission and kind of our authority. And I would urge the associations, I know they're doing a lot, but to do even more as they meet those individuals who are taking the tests multiple times, maybe mentoring those individuals to make it through the testing process. So thank you. Those are all my comments and thoughts.
I will let the board know that I did meet with CCRA, the California Court Reporters Association, last week, and this is very much on their radar. And we have some really dedicated individuals that are pulling out all of the stops to see what they can do to increase the number of candidates, which will increase the number of licensees.
Thank you.
Ms. Brewer, you had your hand up, I noticed.
Thank you. I just wanted to, I don't know if this is appropriate during this item, but to just mention that for all licensees, everybody, I mean, we're getting solicited with this very attractive offers from courts. And I think if we share those with people, it's going to start to build some interest and excitement. I know I've shared these jobs that are available with a lot of people who I know who are looking for improving their career and their income and looking for a profession. And I think we all have a role to play in doing that. Thank you.
And I'll just jump in here and mention that for the board members, the non-licensee, our non-licensee board members, not this fiscal year, last fiscal year, as of last fiscal year, the legislature gave the courts $30 million to recruit and retain reporters. This fiscal year, and I'm sorry, that money is earmarked for that purpose, and it's use or lose money. Excuse me. This fiscal year, the courts have many of the courts have added incentives, signing bonuses, recruitment bonuses, retention, additional salary, and offering part-time positions. So the courts are happily, the courts are using that money, and that is, I think, that I believe is what Ms. Brewer was referring to. Those incentives that very, very attractive. So it's good to see that movement. And I know, talking personally with one of the supervisors at in San Diego, they've seen applicants and they think that it's as a result of those attractive offerings, I'll say. So. I'm not seeing any other hands raised.
Okay, then we will move on to the results of the 2 written portions of the license exam. You'll see the results for the English exam on pages 23 and then graph form on 24, and then professional practice on 25 and graph form on 26. Do we have any questions on the written portions of the exam? If not, I again would like to make a big plug for subject matter experts. Staff is having an increasingly difficult time trying to get people to staff our workshops, which they develop and support our written exams. They're just crucial to us being able to have the good quality tests that we're used to having. It's essential that if you get one of the emails and think that other people will pull it up, it's like, please, if you have any availability whatsoever, we really desperately need subject matter experts to staff these workshops.
And I would add on to that, I know we've got some representatives from the professional associations, please get word out to your members to do just that. It's crucial to moving forward with testing.
And if there are no questions on the exam, then the final portion of my report is on our technology modernization project. Staff is currently meeting twice a week with our project manager to develop scope documents and to learn the management system that will be used to manage the workflow. Although we are awaiting contracts to be signed between the Department of Technology and DCA, we want to have as much work done in the background as possible so that we can quickly move once the contracts are executed. We'll be starting with the online enforcement complaint, followed by the TRF application, all online, and we'll finish with the exam and licensing. After the structure is in place, we will go back in and build out the back office functions. Do we have any questions? I just want to note that it's a big commitment, not only of staff time, but of the board's budget. This has been a long time coming, and we're targeting the essential services with the grant money that we received. But as we build out the rest of the business services, I anticipate additional expenditures in future years. So I'm happy to see that we're keeping the overall fund condition robust so that we'll be able to build this out completely and make it as useful as possible. And I definitely want to give a huge shout out to all of staff because they are really taking on a lot of time. It's really time intensive for them to do that. They're having to carve out time around their existing duties. And when you're as small as we are, that's no mean feat. So I want to really thank staff for their commitment to this project and ask if the board members have any questions for any of my report.
Ms. Hurt?
I don't have a question. I just want to thank staff as well, because I know that this is a really time-intensive process. It's been a long time coming. For as long as I've been on this board, we've been talking about it, and so the time is finally here. And we have such a stellar staff. I know they're doing everything they can to move this project forward, and I just want to thank them all on behalf of the board, if that's okay with everybody.
Thank you. I was
Okay.
going to say ditto, Ms. Hurt. Absolutely. Thank you so much.
It is truly a heavy lift on staff, and I just am very appreciative of their attitudes. It's very easy when change comes to resist it, if you will, and staff has just moved forward with a lot of enthusiasm. I think that all of them have been there long enough to see modernization efforts come and go, and they've started things only to have the work go to no fruitful end, and yet they're jumping in again. And so it's a real, I feel lucky because the resistance isn't there to overcome, and we just have dedicated people. So thank you so much.
Thank you for the update, Ms. Benner. Is there anyone from the public who wishes to comment on the executive officer report?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And audio-only participants can raise their hand by pressing *3 on their device. And it looks like we do have one request for public comment from Priscilla Gwaltney. And Priscilla, you'll be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device.
Okay, thank you. Can you hear me?
Yes.
Okay. Just to follow up on a few things. One thing that CCRA is going to continue to look into is an in-person exam. We do think that that would get us more CSRs. And another one, the candidates do not get to view their exams for corrections, and we understand it's not the time and place to learn what you're doing wrong, but we still think it's important to get some kind of ballpark as far as how many they got wrong at least. So that, or, I also thought maybe the board can have a summary of maybe what the problem is, like, oh, it's grammar, or it's just overall, not just one candidate, but the whole population. How many are missing this? How many are missing that? Similar to what you provide in the professional practice results, except overall. Just so maybe the board, like CCRA, would know, hey, this is where we can help. Anyway. And then the last one, LACRA does put on Find Your Voice. CCRA also helps them with that. And I would love it to provide you the Find Your Voice, the next class, and for you all to attend and get the word out and just see what it's about. We need to get many new students. And so with your help, maybe we could spread the word even more. But I think for now, that's all I have.
Thank you, Ms. Gwaltney. When you say find your voice, I apologize. I was making a note of your comments. You're talking about the seminar. I believe the next one's scheduled for April 9th.
Yes, it's a Saturday, right?
Yes.
Yes. Find your voice. It's to learn more about voice writing.
Yes.
It's like, yeah. Okay.
And actually, I think that's April 8th. It is, but it is a Saturday, right? Thank you.
You're welcome.
Is there anyone else from the public who has a comment on the executive officer's report?
This is a moderator. Pierce, there are no further public comment. Would you like me to close that Q&A panel?
Yes, please. And I see Ms. Hertz's hand raised.
Thank you, Chair. I just wanted to say for the public, some of maybe have been following this, maybe not, but when we first decided to go online exams, I was a strong proponent of having both in person and online. And then COVID hit us. And then we started to think more about what the future holds and how people do need to be flexible online. So I don't know if we're going to take this topic up, and I look to Ms. Finner to talk about what are the thoughts around re-examining the in-person exam process. But I would say when you look at the numbers versus the cost, they're hugely out of proportion. And so I don't know if that truly is a solution to get more CSRs out. I appreciate the public comment that was made, but I think we're going to have to dig a little bit deeper about how we really get folks to the test online. And then I would like to learn a little bit more from Ms. Finner on one of the questions about how candidates understand how they can do better for the next test and kind of what our perspective is on that. Thank you.
So there were two questions there. I would just remind the board that we've talked several times about the costs that go into doing in-person testing. So as a reminder, we have a dictation room that we need to reserve. So that's a big meeting space in order to read the test. And then there's another very large meeting room where the candidates do their transcription. And so we take up a lot of meeting space. In the old days when we had several hundred candidates, it was easily, we would get a reduction on the meeting space because we took enough sleeping rooms. For people that aren't familiar with hotel and meetings, when you look at booking that, they offset how much they're going to charge for your meeting space based on how much income they think that you'll bring into the hotel with your event. So if you have a lot of sleeping rooms, if you're booking dinners, if they expect to make up the income that way, then they can give you a discount on the meeting space. Because people come in, take the test and leave, we have very few sleeping rooms. It's mostly just staff. And so we don't get any discounts. So paying full price for large meeting areas, I can tell you the numbers that we had pre-COVID in Los Angeles, they were around $20,000 just for the meeting space. More closer to $10,000 in Sacramento just for the meeting space. The costs on top of that would be the travel costs for the readers who dictate, as well as staff. We usually use volunteer proctors to round out staff because we don't have enough staff to proctor the entire exam. So it's a commitment of staff time, and then obviously the costs involved in getting them there. And so it's the travel and the other expenses associated with that. So bringing those costs into post-COVID, you can see that it's a lot. But but it's the board's pleasure, the board's budget, if that seems to be worthwhile for the number of licensees that we will gain from that. We'll do it, do whatever the board's pleasure is. Your second question was on the feedback from the exams for the candidates. So I think I have more than once said, this is not the place for you to practice. This is the place for you as the candidate to show whether or not you're ready to go. And I understand that every time you take a test, you want to know how you did. Unfortunately, this is not the place to do it. As somebody who looks at anybody who's even not like barely passing, but anywhere within 15 errors of passing, I look at each one of those tests. And I can tell you generally, people aren't fast enough. It's drops. People are not missing by 1 or 2 points. They're not missing for a few punctuation errors. They're just not fast enough and accurate enough to pass the exam. I'm not sure how we get specific feedback to specific people. It's just not as black and white, I guess, as the written test questions are. It's a different format, so I'm not sure really how to address that. But that's the information I have for you.
Thank you. And I'll say I don't know if I have an opinion yet too on the in-person exam, whether we need to go back to that topic, but I know we have strategic planning process in which we can talk about all these things and really dive into it around the table and talk about the pros and cons. So thank you for answering my questions. That was really helpful for myself and the public.
Thank you. And Ms. Brewer, you have your hand raised?
Yes, thank you. I just had a question about online exams, not ours, but industry practice. And I know NCRA has gone to all online exams, and partly actually because it's more accessible to candidates, particularly people who live in rural areas, but also cost-wise. But I'm wondering, NVRA, I don't know specifically, although I think that they are online, and I'm wondering if you know and can share that.
I know that NVRA tests in person because part of what they're testing on the voice writer side is how audible the candidate is.
Any further questions from the board? Well, thank you, Ms. Fenner, for your report and all the information that you have provided. Appreciate it. And with that, I think we'll take, how about a 10-minute break before we go into legislation, our next agenda item, number 5.
President, this is legal, if I may. Could, due to the substantive communication, could we go ahead and ask for public comment one more time, please?
Thank you. Yes, I will do that. Public comment. Is there any in regard to the discussion we just had, the further discussion?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And it looks like we do have a request from an individual signed in as Ruby. Ruby, you'll be given 3 minutes to speak in a 30-second warning. Please click the unmute me button when the prompt appears on your device.
I just wanted to follow up on the request to bring back the appeal process. Not so much to see errors, but just in the name of transparency. It's nice to know that your test was successfully received at the other end. No chunks were missing, or because sometimes I've seen that on RTC. And it's in the codes, I believe, that we should have a right to appeal. That's number 1. Number 2, you might get a couple more court reporters out there who successfully appeal? That's number 2. And number 3, what's the reason for just denying it? That's all. Thank you.
All right, and this is the moderator. Appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, please.
Chair Sunkeys, I can answer the questions from that person quickly. We have gone through it at past board meetings. The code that she's referring to is a regulation, not a code, and the board did vote to approve language to rescind that particular language because of the new format. So when we were in person, we gave one test, and when the test was done, there was no reason for it not to be shared. The way that we do it online is the same as we do with the written test. There are a bank of test questions for the written. There are a bank of audio-visual tests for the skills portion. And they are a finite number. They're very expensive to create. And for security reasons, they're not throwaway. We reuse them again and again. So when a candidate takes a test, they're locked out from ever taking that one again, but there's a test bank supporting behind it so that they can come back and retest. That's the reason that there is no access to the exact test that you took. So there's no way for you to appeal because you don't have access to that test. Because that appeal right has gone away, the graders are, I don't want to say they're more aware of that fact, but when we review the tests, after years of seeing what type of errors or what type of things go to appeal, we're very lenient with that. So we're very mindful of the types of errors that we're looking at. And I can absolutely assure anyone that people are not missing this test, not passing the test by 1 or 2 errors. The closest that they come is over 10. And so that's the information that I can share with the board.
Thank you, Ms. Fenner. Any further comment from board members? Then I think we will take, unless I get another cue from Ms. Joffrey, I think we will go ahead and take a 10-minute break before we move into agenda item 5.
Meeting is being recorded.
Welcome back. Let me make sure we have everybody here. See Ms. Tagati, Ms. Brewer, Ms. Hurt, Mr. Manayan. I don't see a camera, so I just want to make sure you're here. If you could raise your hand or pop on, just to let us know you're with us, please. We'll just give him a minute. Board Member Manayan, are you with us?
Madam Chair, I can conduct roll call. We do have a quorum, it appears, but I can establish that if you'd like.
Okay, that would be great.
Thank you. Ms. Brewer?
Brewer present.
Thank you. Ms. Tugade?
Tugade present.
Thank you. Ms. Hurt?
Hurt present.
Thank you. Ms. Sunkis?
Present.
Thank you. We do have a quorum.
Okay, then we will move on to agenda item number 5, legislation. Ms. Fenner, would you like to present that agenda item for us, please?
Thank you, Chair Sunkis. Beginning on page 27 of the board agenda packet, you'll find a list of bills that we're currently tracking for this legislative cycle that just started. As a reminder to the board, you can take a support position, you can take an opposed position, or you can remain neutral and we'll just continue to track it. So AB 709 by Assemblyperson McKinnon deals with allowing a prosecutor with possession of a transcript that contains potentially exculpatory or impeaching material that involves a police officer witness. So it's a very specific case. It provides the permission for the prosecutor to provide an unofficial copy of the transcript to defense counsel or a defendant who's appearing in pro per. It would also allow the defense counsel to reproduce a copy of the transcript as an exhibit. And as background, I would just share that existing law typically prevents or prohibits the sharing of any copies of transcripts. Would the board like to discuss this bill?
I will open it up for discussion. Is there any member of the board who has a comment? Ms. Tugade?
I was looking at the text of this legislation, and my understanding is that, if you look at the text of the legislation, it's really looking at a very, very specific scenario around Brady cases. So those are cases involving law enforcement. And so I was curious, and I understand these are such specific cases, but I'm wondering if we might have any sense of what potential impact this might have on court reporters, to the staff or to our licensee members, in terms of, just a sense of the number of transcripts that this would number.
Well, I can tell you that after having worked nearly all of my 37 years in court, I expect this would be a very minimal amount. However, my concern, and I will admit that I have not read the language of the actual bill. I'm going by our synopsis here. But when it says provide an unofficial copy of the transcript or relevant portion thereof, is that language from the bill itself? Because it would, I'm sorry.
Yeah, what I read you was exactly the language of the bill.
Okay, because I would be even less concerned if it were just or the relevant portion thereof, because why should they get the full, say, perhaps it's a preliminary hearing and you've got one police officer witness, and if it were or relevant portion thereof, then it would be perhaps they provide, in this limited circumstance, they provide simply that witness testimony to the other side. But so that would be my only concern. But having said that, again, I would expect that to be very minimal, few transcripts that would be affected. But it is giving away a court reporter's transcript. Did that answer your question?
I have
Gotti?
a follow-up, but I'm happy to defer to Ms. Hurt first.
Is it on the same topic or is it some on a different issue on this?
On a different issue. So.
Okay, then I will go to Ms. Hurt and then I'll come back to Ms. Gotti. And then I see Mr. Manayan. Thank you.
So one of the missions of the Court Reporters Board is to protect the public and secure the record for the public's benefit. And so one of the questions that's kind of coming to mind for me, it's maybe a little bit different than Board Member Takati's, but what does Ms. Finner see as a negative public impact of this bill or not, maybe? Just curious how this impacts what we deem as the public and why we're here protecting the public when it comes around the record.
So it would benefit the defendant because they would not have to pay for that copy.
I just would like to add that defendants, if it's a preliminary hearing transcript, defendants receive those in due course free of charge. But
okay. I guess for me, I'd like to take a neutral stance at this point and watch it. I don't foresee the other options as the direction we should go at this point, but that's my initial reading.
Thank you. I believe I said I'd go back to Mr. Gotti and then Mr. Manayan.
Thank you. My follow-up question, in the interest of, again, protecting the public was around if this might have any impact on access, if, again, I suppose it is sort of a follow-up to my previous question around, if this, is a bill that is in some way requiring our court reporters to give up a portion of their work without pay. Would this somehow impact, court reporters taking up work in some format? If any of our licensees or staff would be able to speak to that.
I really don't have the background working in court to have any kind of feel for that. So I would defer to our chair as the official, and then if we get any public comment.
And clearly, if we're being asked to provide, if this gives the DA the ability to share a transcript, which they otherwise would not be allowed to share, correct? They would get the transcript from the DA, the attorney, or the pro per defendant would be able to get the transcript from the DA rather than go through the court reporter and pay for it. So it would clearly have an impact in that regard. And Mr. Manayan.
Yes, thank you. I agree with Ms. Hurt that the board should take a neutral stance until these things develop. But and I understand that this is a very narrow exception, very narrow situation, and might hardly have any of these moving forward. But once you start creating an exception for one thing, it sets precedent for exceptions for other situations. So I'd be cautious in the impacts of this. While immediately it might not make much of a difference, I think it could set precedent for additional exceptions, which could hurt our licensees. So just to keep that in mind.
Thank you. Ms. Brewer, I see your hand raised.
Yes, thank you. I just wanted to concur with Board Member Manayan and Vice Chair Hurt. I think for the time being, as things develop, a neutral position is probably appropriate. But I had kind of the same concern in the back of my mind about a precedent being set. And, things are this way for a reason. Having not been an official, I'm really reliant on the advice and experience of our chair for this matter, but I just doing anything other than taking a neutral position at this point to me seems perhaps premature until we see where this goes.
Thank you. And may I ask, should we take a vote on each of these bills as we go along as to what position we want to take? Is that that? Okay. Mr. Gotti, I saw your hand up. Did you have a further comment?
No, I was going to make a motion to remain neutral on the legislation, although I don't know that we even need a motion for that.
It sounds like we do. So do we have a...
You would want to do public comment before, well, I guess you can do the motion and then the public comment on the motion.
Okay.
There would need to be a motion and a second, and then we could take public comment.
Got it.
So I'll second.
Thank you. So we have a motion and a second to take a neutral position on AB 709. Is there any public comment?
This is a moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And it appears there are no requests for public comment. Would you like me to close that Q&A panel?
Yes, please. So we've got a motion and a second. Does this have to go, does Ms. Bruning, call for the vote on each item? Okay. Ms. Bruning, would you please call for the vote?
Thank you, Ms. Brewer.
Aye.
Thank you, Ms. Hurt.
Aye.
Thank you, Mr. Manayan.
Aye.
Thank you, Ms. Chagade.
Aye.
Thank you, Ms. Sunkis.
Aye.
Thank you. Motion carries.
Thank you. And Ms. Benner, you want to move on to the next bill?
5.2, which is AB 1070 by Assemblymember Lowe, is making a non-technical change to the board member vacancy provision. So we're just watching that right now. 5.3 is SB 21 by Senator Umberg, and it talks about remote proceedings for continuances and postponements. I think the more substantial bill before you is 5.4, which is SB 22 by Senator Umberg. Again, it's remote proceedings for different civil actions. Right now, there is a provision to allow remote proceedings, and these two bills, I should say, would extend the sunset dates for that. So SB 22 would extend it to January 1st of 2028. I don't know if the board wants to discuss that, if there are any questions.
Are there any questions from the board? And the current sunset date is July 1 of 23, correct?
I think it's January 1 of 2024. So this would extend it out a further 4 years.
Got it. Okay, thank you.
And I just want to be clear for the board that this is not particular to court reporters. There are different provisions that require the court reporter to be present in the courtroom. This is more general. These provisions are more general for other people that are involved in the litigation to appear remotely.
Thank you. Ms. Hurt, you have your hand raised?
Yes, I do. My question is, has anybody come out against this bill? I'm just curious who they are.
And that question is I don't know the answer to that. I was going to definitely open this up for public comment as well. And since I see no other hands raised from board members, perhaps we should do that right now because this is clearly on our agenda. This bill was on our agenda. So let's open it up to public comment.
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And it appears, I apologize, we do have one request for public comment. From Janice O'Malley. And Janice, you'll be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device.
Hello, this is Janice O'Malley representing AFSCME, the American Federation of State, County, Municipal Employees who have court reporters all across the state, and hoping that you all can hear me.
We can.
Okay, great.
Yes.
I did want to flag that we are in an oppose unless amended position on Senate Bill 22. We have been working with the author's office on the bill. I believe he has committed to remove the part of the bill that would allow for remote court proceedings in criminal proceedings. But there are still outstanding items that we're concerned about, specifically the requirement. We sent in a letter, and I'm happy to share with folks if that's helpful, but we would like the judicial officer to be physically present in the same room as the court reporter and court interpreter during remote proceedings. We would also like that the JCC adopt standards on what technology is minimally required to conduct remote proceedings. And we'd also like to include a way for interested parties to provide feedback on remote court proceedings on their websites, and have the JCC compile that information and submit it annually to the Assembly and Senate Judiciary and Public Safety Committees. And that is my comment.
Thank you.
Board President, if this is legal, if I may?
Yes.
I believe we were discussing a different legislation, and so those comments would be outside of the scope of the topic that we're speaking on. Of course, we can remember them for SB 22, but I did want to make that note that the board has, unless I've missed something, has not yet discussed SB 22.
We are on 22.
Oh, are we? My error then. Thank you.
Any other public comment?
This is the moderator. Appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, please. Ms. Hurt, I see your hand raised.
Yeah, that was really helpful to hear from the public, and makes me curious to know and understand more that's outside of the language of this bill. I'm curious whether, I always forget the timeline. In other words, if we have to take a stance, is it now, or, waiting for the next meeting almost sounds like inappropriate. The time would have come and gone. And so I'm wondering, because we don't so clearly understand, and I think I still have a lot of questions, what folks are thinking about a stance we should make. It sounds like it clearly needs to be amended And, is it support if amended, so a more positive language? So, because it seems like most folks are in favor of remote reporting. I haven't heard folks strongly against it, but it sounds like the circumstances are really important and the criteria and the details around it. So it sounds like a longer discussion that we definitely should be a part of. Not sure if I want to take a position, but would like to hear from other board members on their thoughts around this, support if amended or oppose if amended. Thanks.
Thank you. Ms. Tagade.
Yes, speaking to Ms. Hurt's question around our timing, I actually would, considering the concerns of that were raised during public comment, I would second kind of holding off, perhaps not oppose unless amended or a support, perhaps not a position quite yet, but typically it is appropriate to wait until even July to take a position, or August, for and I'll defer to Yvonne, of course, to Ms. Fenner, of course, but it is often for state agencies that is a typical time to provide technical assistance, and so I think that is appropriate for us to defer on that, especially given this bill is very complicated and goes beyond just our court reporters, and so I think it would be really helpful for us to consider how not only the impact on our court reporters, but kind of the larger ecosystem too. And so perhaps we can work with Mr. Umberg as well.
Thank you. So do we have, and Ms. Brewer, your hand, I see, is up.
Yes, thank you. At Vice Chair Hurt's request, I just wanted to voice my sentiment about this. I agree with what Board Member Tagade just said. I think if we could defer, especially since the AFSME and perhaps others are in negotiation to make changes, I'd like to see us wait, especially if it's appropriate generally to wait until a little later in the year.
Okay. Thank you. And I've got a question. Do we need to take a formal vote to continue to, if our position is we want to just continue to track the bill, do we need a formal vote to take that position?
I don't think that you do, because it will stay on my list of bills that I'm tracking.
Okay.
If there would be amendments that I think are critical for the board to address, obviously I would let the chair know right away. We have the ability to call a special meeting or just set a board meeting. We just need to make sure that we give the proper notice to the public.
Thank you. Okay. Ms. Hurt, I see your hand up.
Yeah, I appreciate the conversation and discussion we just had and the executive director's statement. I'm wondering if we should ask whether Ms. Finner can reach out directly to Umberg's office to start a conversation about its impact. I know you said you'll watch it and see how it affects court reporters, but do we want to be more proactive than that in our direction?
So I will share with the board that I did testify at an informational hearing that Senator Umberg held on remote proceedings. And so I heard a lot of testimony from a lot of different stakeholders, and also provided feedback from the board on availability of court reporters and some of the concerns that the board has heard we've heard from licensees who say that they've had excellent experience with remote trials. They're typically civil trials where people have been holding the depositions remotely, and they're very experienced. They have good internet bandwidth. They have good quality equipment. I've also heard, I being the board, we've also heard feedback from officials that have not been able to hear the witness and have not been able to notify anyone that they're unable to make a record. So it runs the full gamut of very good experiences to very bad experiences. So I think that we are in the loop, Ms. Hurt. I think that the board is in the loop with Senator Umberg's office as far as giving feedback and watching what other stakeholders are adding into the discussion. If you have a specific concern or something specific that you want me to share with the Senator's office, happy to do so.
So that's really helpful. Thank you for sharing that you've had that exchange. I just don't want something to fall through the cracks, especially as it's really important to our mission. I mean, not being able to hear or see the witness very well because of the equipment that's being used is really important to the work that we do and making sure that that does not happen as we protect the record. So I feel confident you'll watch it and let us know if we need to address it quickly in opposition or support. But I do want us to make sure that we follow it closely. So that's all. Thanks.
Thank you. And seeing no other hands, I will ask Ms. Spinner if you want to move on to our final bill or two.
Okay.
There's one more on the agenda.
Yeah, the last one on the agenda I put on there out of an abundance of caution. It right now continues to just be a spot bill. So we're just watching that. We did get a latecomer. So SB 662 by Senator Rubio got into print after the board agenda was published. I do think it's important that the board discuss it because it does have a lot of provisions and impact on court reporters and the board. It would authorize the Court Reporters Board to issue a provisional license that would be valid for 3 years to anyone holding the RPR or to anyone that is eligible to take the CSR exam. The bill also would permit courts to expand the use of electronic recording in civil cases. It would offer court reporters, licensed CSRs, a first right of refusal to transcribe those recordings. The bill also includes language that the CRB should allocate funding toward recruitment and retention by publicizing the profession to high schools, vocational schools, and higher education institutions. I'm happy to answer questions on the bill if the board would like to discuss it.
There is a lot in there. Ms. Brewer.
Yes, there is a lot in there for sure. Okay, so first I'd like to say that I really like this idea of provisional licensing, although I personally cannot support providing a provisional license to people who have qualified to take our test. I think that's just exchanging one problem for another and is really, I'll just call a spade here, very ill-advised. As far as the ER provisions in this bill, I think they need a lot of work. We as a board are responsible, as everybody has said repeatedly, for watching out for the rights and the interests of the public, of the consumer, and just the way that this bill contemplates introducing ER, to me, is extremely problematic. And I'll leave that at that. So personally, I can't support those provisions. Okay, we discussed, and one other thing about this idea of right of first refusal of a CSR to transcribe an electronic recording, that is not sufficiently fleshed out, and I just can't support the ER provisions in this particular bill. But I really would like to see us talk about the provisional licensing of the RPRs, and personally, I'd like to see us provide provisional licensing for CSRs from other states. I mean, we have a problem, and if we can introduce more CSRs in the short term, it will definitely be of benefit to the public. And I think I'll leave it at that for right now.
Okay, thank you. Ms. Tagade?
Thank you, Chair. I come from the healthcare space, and provisional licensing is not a new concept. We use it across much of the healthcare profession. But my concern is really, the devil is in the details here. And my concern with this legislation is that there's really no structure of consumer protection built in to this provisional license format as it stands here in the way that we have in the healthcare profession. And so typically when you're issuing a provisional license, while that individual has a provisional license, there is a supervisor, a facility, there is somebody's license who is liable. There's somebody on the hook, and somebody who, when we say supervising, really ensuring that individual is being, trained properly, is getting that hands-on, training, is getting, is really being led into the profession. And so, again, we'll lean on our colleagues here to kind of speak to, I struggle to understand how you could have a supervisor really kind of help in that same way that we do in the healthcare profession, and maybe it is possible in that kind of like hands-on on the job training that I believe in very strongly. But my concern is really like we have to have that liability structure, particularly when the record is being protected, and so I would even go so far as to say to encourage like an oppose unless amended stance or some really really strong stance on this legislation given these concerns, because it's really stands in contrast to the Department of Consumer Affairs' charge of protecting the public. If we do not have some way of holding accountable our licensees, and I think that issuing a provisional license without having some form of supervision really kind of leaves a gap there.
On that issue, I have a question for you, Ms. Tagade. In the healthcare field, if a provisional license is issued, is that a person who has been licensed in another state, perhaps? So have they been tested by somebody before they're given a provisional license in California?
That's a great question, Chair. There are a few, it really depends board to board. Okay. And classification to classification, but broadly, there are there are like associate licenses that are provided, and sometimes that limits the scope of what that individual is able to do. So perhaps they're able to do this amount of scope, and they cannot see patients on their own, or they can do this, but they must report all of their patients to their supervisor every week or something like that. And so there's different checks ensuring that there's, quality to their work.
Thank you. You had mentioned that you had raised the question about how would they be supervised, and I would just offer as a licensee that I could support if they had perhaps their RPR or their CVR from the NVRA organization, the Voice Writers organization, who, by the way, certifies both steno and voice writers, or even someone who's licensed in another state. And because I see if we were to offer provisional license to one of those individuals, we know that they've been tested, and so they've met the standard, that testing standard somehow. I can say that if they go to work for a firm, they're going to be they're going to be monitored and mentored by that firm. And that's assuming if they're a new reporter. If they're an established reporter somewhere, they've been doing this work. We need to ensure that they're complying with our laws in California. And of course, if they go to work for a court, the court's going to have rules and supervision. So I will just offer that as maybe perhaps some feedback to the issue you raised. I see Ms. Finner's hand raised, but I also saw Ms. Hurt's hand. Is that in response, Ms. Finner, to my comments?
I just wanted to add a clarification that the way the language is phrased right now, it is contemplating provisional licensing only for official reporters. It would only apply to people going into court. And then I also wanted to ask Ms. Joffrey to give us a clarification on taking a position on this bill.
Yes, so this bill is not noticed as something that the board can take action on. The notice did provide that this legislation or any legislation that came up after the agenda could be discussed with enough specificity for the board to determine if either another meeting or a special meeting needed to be set. And BagleyKeen does permit for legislation to be discussed, but at this time the board could not take an official position at all. However, you can provide Ms. Fenner the information she needs to reach out to the legislative office, and at that point determine or coordinate with the chair whether or not a special meeting is necessary or to place it on another agenda.
Thank you. Ms. Hurt, you've been very patient.
Oh, yeah. That actually answered one of my questions, which is we can't vote on this. So I appreciate our board attorney answering that one. And then I just want to echo from board member Brewer and Tagati this concern. I think it's really not a solution, but it's possibly creating another problem. And one of the things that I read, and I would love to be corrected if I read it wrong, which is, people who've taken this test for, let's say, 10 years and haven't passed could receive a provisional license on day one. And going back to our mission of protecting consumers, it absolutely does not do that. In fact, it may put them in great jeopardy because the court reporter is actually just not ready for all the reasons that have been stated during this meeting. I do support the senator, trying to be creative and bring solutions to what is definitely a problem and an issue that we've seen. And maybe in our strategic thinking, we can dig more into the provisional licensing idea and how that can be expanded in ways that are protective of the consumer and the public. And I will also say I have concerns about us, if funds are not delivered from the legislature to us, and we have to use our budget to mandate, the search. We have a small, tiny budget, and so we really have to think for the long term how we strategically put money aside for what the bill is asking us to do, which is to go to high schools and promote, which is not something that's probably going to be inexpensive, and also community engagement is an expertise that's important. So we would have to really do some investment in that space. So I too was sitting on the oppose unless amended. I know we can't vote on that, but I want the executive director to know that's where I'm leaning, and that she should continue to work with additional stakeholders in Rubio's office so that we can get a better bill maybe out of this. And again, I would like to know who opposes this. And so maybe the public can support us in that information.
Thank you. And I will just say that as we're having some discussion about this, one of the things we're going to be getting into in strategic planning is ideas. Let's think outside the box. Ideas to increase the number of licensees we have in the state. And I like the idea of provisional licensing if it's crafted properly. And so I think I think it's timely. This bill happens to have come up before we even got into our discussion on strategic planning. I think the topic is timely. So I have concerns about the expansion of electronic recording, the way it's written in this bill in regards. It's not specific. If they install ER, are they required to have an ER monitor in each courtroom to ensure that the record is being protected to the extent it can with ER? We know that that a court reporter is the gold standard for making the record. And if we and our job is to protect the consumers of California. So if this bill goes into effect and they do install ER, what does that look like? It's not clearly laid out. So those are my thoughts. And the idea, well, I'll just leave it at that. So if there are no other comments from board members, shall we open? I know we did. I'd like to open it up to public comment and get public comment on this bill.
This is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. It looks like we have a request from a couple individuals, so I'll go in the order they were received. First, we have Janet Harris, and Janet, you'll be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device.
My name is Janet Harris. I am the current president of the American Association of Electronic Reporters and Transcribers. I also am the vice president of enterprise sales at Stenograph. I wanted to point out that AAERT does offer certification and continuing education requirements for certified electronic reporters and certified electronic transcribers. We do not support unmonitored electronic recording systems making a record. We do support that a trained professional who is responsible for the capture of the record and production is available
for any instance where a record needs to be made. And I also would like to just put forth that the board consider AAERT certification along with granting provisional licenses to someone who has already passed the CER exams or CET for whatever function they may be involved in producing the record.
Thank you.
Thank you.
All right, this is the moderator, our next individual who has requested public comment, Janice O'Malley. And Janice, you'll be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device.
Thank you, much appreciated. Again, this is Janice O'Malley with the American Federation of State, County, and Municipal Employees, representing court reporters in the state. Just wanted to flag that Senate Bill 331 has been changed. It's no longer related to electronic recordings. It's actually now on child custody and child abuse and safety. The bill has been changed to Senate Bill 662, also by Senator Rubio. We, in coordination with the Service Employees International Union, the California Labor Federation, and others, met with the senator on this bill, but we're concerned that giving reporters with the first right of refusal to transcribe anything that is currently authorized in the statute is a slippery slope, especially since we're concerned just with the idea that we would record everything but criminal and have officials just be transcribers. We are in an oppose unless amended position and still are in that position. And really appreciate the conversation that this group has had regarding the bill and agree with all of the concerns that were raised. Thank you.
Thank you.
All right, this is the moderator. Appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, please. Any further comment amongst the board?
Through the chair, I'll just quickly say it looks like we may be needing a special meeting here in the near future if the legislation like this one and the other one that we looked at continues to be amended and is out there for review. That's all.
Thank you. Ms. Joffrey? Oh, you're muted.
I'll try again. I did want to advise that a special meeting does require additional notice, but it can be done with less than 10 days notice. But this board can also set for an additional meeting, which just simply means it gives the public a full 10 days notice. So I believe by the term special, it may mean just an additional, but it is an authorization to set a short notice meeting, which would be a special meeting. I just wanted to make that clarification.
Thank you. Ms. Fenner?
So I just wanted to make sure that I understand the board's position so that I can give good feedback to Senator Rubio's office. Dealing just with the provisional licensing aspect of the bill, is the board generally in favor of allowing reporters that have been licensed in other states? I would probably recommend that the license be in good standing without any disciplinary action outstanding against it. Let me take them one by one. Is everyone in favor of that particular provision? Or if there's anybody opposed to the things I'm going to list out, maybe that would be the more efficient way to do it. So I heard yes on licensees from other states. Yes,
I actually have some concerns with that, Ms. Fenner. And I would say I'm not opposed to that idea, but I would I would strongly encourage having some guardrails around that, as you mentioned, around ensuring that the licenses are in good standing. But additionally, perhaps requiring some, similar to what we have for some of the special licenses, like the is it the Gold Star family? There's some additional special licenses that we currently have where there's a time limit of 1 year or whatever, where the person is then required to be licensed in California. I would encourage something like that, where there's some sort of time limit.
I think that the bill right now contemplates 3 years. It gives the provisional licensee 3 years to complete our license exam. So it's not an automatic granting. It's just an ability to practice while they are taking our exam.
And this is legal, if I might. I did want to caution against taking hard positions or stances, and perhaps limit it more to what questions does the board have, or more generic. I'm a little concerned about, does the board support this, because we cannot take that action, if that makes sense.
Might I suggest, what comments do you have on this topic, as opposed to taking a position? I don't know, to give you feedback, Ms. Fenner.
Okay, let me just go down my list then, so that I'm clear on the concerns or questions.
And I'm going to interrupt you, and I apologize. Both Ms. Brewer and Ms. Hurd had their hands raised. So I believe on that topic of the other being licensed in another state. So Ms. Brewer, if that was correct, did you want to address that?
That is correct, although I'm happy to defer if it works better to allow Ms. Fenner to go through her list and then comment.
Perhaps that's the way to go. Maybe we could. So go. Would you like to do that, Ms. Fenner?
Do you mind if we, through the chair, do you mind if we just take them one by one? Because we all may have different ideas around the points that she's making. So, if Ms. Brewer wants to go next on this point as it relates to states, and then I can go after her, if that's okay with folks. I think it'll just get confusing, and Ms. Fenner won't get all the discussion points she needs to move forward in.
And let me thank you, and we could do that. I just want to say that I'm being told that there were a couple people who wanted to make public comment that that we closed the window too soon, and so we'll go through this discussion. But I will be sure. It's my intent to open for public comment after we've had this discussion, for those who want to do that. If I forget, please someone remind me. Ms. Fenner?
Okay. So I did have a comment. I don't know if Ms. Brewer, Board Member Brewer, wants to go now, or
I'd be happy to go ahead, and I'll be somewhat brief. So, as I mentioned previously, I am strongly in favor. I'm a proponent of having provisional licensing now, and as people have mentioned, with some guardrails, absolutely opposed to the idea of the students who've qualified. But as far as RPRs, I would be in favor. As far as the CSRs from other states, I really wish we could, I know this isn't feasible, but I really wish we could say which states we would accept, because not all CSRs are created equal, unfortunately. So I suspect that the only way that we can control that is by the period of time within which they need to pass our CSR. And so the other question that occurs to me is, what if in that provisional period of time they try and fail to pass our CSR? I mean, that's just something to think about. And I'll leave it there for now.
So I'm sorry, can I just address that quickly to get it off the table? If they did not pass the test within the 3 years, their provisional license would go away.
Ms. Hurd?
So as it relates to licensing other court reporters in other states. You know, we go through an occupational analysis. It's one of the conversations we had with Texas that did not equate to the standard we have in California. So I would be very cautious about just opening the door to all court reporters in other states because of the differences in licensing requirements and standards. I really think that this is an in-depth conversation that takes more research and understanding. Because again, I'm supportive of provisional licenses and maybe even other states, but do we know whether they've gone through occupational analysis? How equal are they to the standards of California? I don't know. So I feel like it's almost hard to just blanket say, yeah, go ahead, give it to the states. Those are some of my feelings.
And I would just offer as feedback the idea that this is a provisional license. And though I know that Texas has an adequate test of entry-level skill for reporters, we have rules in California regarding the occupational analysis, which prevented us from offering reciprocity. We're not talking reciprocity, we're talking provisional. And I think that if someone has their RPR or their CVR, and I would go so far as to say a license in another state, that at least gives me the assurance that they should be issued a provisional license with we not blanket. We know that there are requirements to go with it, but just as who could be considered for issuing that provisional license, I think that would be fine. And we're not saying that they wouldn't have to still pass our test. We clearly are saying that. So that's, I think, how you address the requirement for the occupational analysis, and that they pass a test that's legally defensible, which is what our requirement is for our board, I believe.
If I could just add, Chair, we talked about it earlier about stepping stones to doors being open wide for changes. And I mean, this would be one of them. I mean, if people are able to get provisional licenses and there's an argument to be made, then why does California have these kind of high standards, and why wouldn't we open the door to reciprocity across the United States in light of the fact that they can get this job done? I'm not saying that's necessarily a bad thing. This could actually be a good thing. But I do think it's complex, and we do need to kind of talk about all the different ways that this can be positive or negative.
Thank you. Ms. Fenner?
The other thing that I took a note of during the discussion was Board Member Tugade's point about the lack of a supervisor being on the hook. And so I can share the board's concerns regarding that. I'm not hearing anybody in favor of allowing the people that have qualified through the schools. Is there a time limit you would want that would be contemplated, that, or just no, we're just wanting RPR, CVR? Are there concerns?
I would like to address actually the comment about, do they need to be supervised? I actually don't think it would need a requirement for supervision. I think it's built in, and because they've been tested to do the job, I think that gives us the assurance I wouldn't require that they would have to have a supervisor. That would be my position. And I will open up the second point to the rest of the board. I have a comment too in regard to the time. Does anybody else have feedback on if there's some portion of a time limit after I guess it would be after qualifying, say, a student right out of me. I will say this, I will just jump in. I'm sorry that we know as licensees that we are best prepared. We are writing our tip-top best right out of school. And we're writing regularly and we're writing a lot. And I think at least for me, that was when I did my best. And best able to pass exams. And the concern with opening it up to anybody who's qualified to sit for the test is very concerning to me. I think I'll just leave it at that. But if perhaps the window, from qualifying as a student to sit for the test, maybe a 6-month window, so we know that those people are very close to that time when they're writing their best and at the top of their game. I think that would be something to consider. And I will open that up. I see, I don't know, I believe Ms. Brewer, you were first, and Ms. Tagata, you were second.
So I've heard other reporters express that, what Chair Sunke said, that they felt that they wrote their best when they were practicing and right at the point of taking the test. And that's what people told me when I did my mentorship, internship. And for my part, I completely disagree. I can tell you that my skills have improved throughout the 40 years that I've done this job vastly. My skills have improved vastly. And there's no way that I would want to be faced with going out on any job with my CSR level skills. And I passed the CSR the first time. I passed my merit the first time, which you can't take until you've been 3 years out of school. So I as a working reporter, every single job that I've taken, I've been challenged. Every single job. And so I just cannot support the idea of dropping a minimal requirement standard that is there to protect the public. I can't go there. And I agree actually with Chair Sunke's on the supervision point. I listened with interest when Board Member Tagata brought that up, because I think that's a very interesting point, and I was thinking about that myself. You know, this is a solitary profession. We work out on our own. And so even as a brand new reporter, you're faced with going out to the job on your own. But there are so many things more than just the writing and reporting. We have a lot of rules and laws and requirements. And so supervision of those, I think, could be helpful. But especially people coming from other states who have not yet passed our test, maybe haven't studied for our written test. And that's part of the concern that I have about just opening it up to any state CSR as well. Because I think that our written knowledge tests are unique and relevant and robust and provide consumer protection. And I'm sorry, I've gone on too long, but I'm pretty passionate about these issues. I've always been passionate about skills. And, you know, if we're not about skills, what's the point?
Thank you. Ms. Tagata.
Thank you, Chair. You know, I'll second much of what Committee Member Brewer stated. But, you know, in hearing everyone's kind of further discussion around supervision, I thought it was important to actually clarify, you know, like I mentioned, the formats of these kinds of provisional licenses in the medical world can vary dramatically, and they change as these individuals kind of gain skills, gain their certifications, and grow in their kind of tier in the learning process. And so that, you know, that is another thought is, you know, I would almost liken this more to the relationship between, and without getting myself in trouble, between perhaps a nurse practitioner and a physician, rather than an associate social worker and a licensed clinical social worker, perhaps, where this is someone who is practicing with a level of independence that they're really they're independent essentially, but where, to your point, there are a lot of rules, there's a lot of paperwork, there's a lot of precision that needs to happen, and that is where, again, in terms of protecting the public, it is really important to have that level, those layers of oversight. And so perhaps, it's not black or white. Is there supervision or is there not? There are ways to have independence and supervision at the same time. And so it's not necessarily someone sitting over your shoulder and making sure that you're taking the transcript. Supervision can look a lot of different ways, even in the medical world, and I imagine here with court reporters. But again, wanted to kind of underscore that point. And just one last comment. I would be remiss if I didn't bring it up. I just wanted to add to the record that I found, in looking at the legislation, a lot of the findings and declarations to be problematic. And I wanted to make sure to have that in the record, that if we did take a position and to make sure to raise that with the author's office, that frankly, much of this is inaccurate to my experience on the board. I think that, the board has been doing a lot of work to correct some of these issues, and that, some of those numbers, I'm unsure where they've been pulled from. And so wanted to ensure, even though it's just findings and declarations, that does get entered into the record, and gets used, in further, when informing statute and policy. And so I would be concerned if that moves forward. Another just quick note on the point of directing the board, again, to address sharing the profession outwardly. Again, that has been in our strategic plan. We're continuing to address that. We've been we just started licensing firms. We just started licensing voice writers, and so it's something that we talk a lot about in the legislative world is that you have to let the process actually work well. And so my concern as well here is that if we don't just kind of allow that process to move forward, then we won't actually see results. So in any case, those are my comments here. I'll leave it there.
Thank you, Ms. Tagade. And not seeing no further hands on the board, I will move to public comment, to reopen the public comment.
Great. This is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And I see that we have a raised hand from Priscilla Gwaltney. And Priscilla, you'll be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device.
Hello again. You can hear me, right?
Yes.
Okay, good. So CCRA has not had an opportunity to speak about this bill as a group. It's so new. So I'm speaking personally, my personal opinion. And I do work closely with students, very involved. And I do agree with the majority of you. I do. The pass rate is the RPRs, they pass it. It was 75% or something on average, probably. CBR is kind of too soon to tell. The group that's not nationally certified, what is it, maybe 9-10% pass rate? I do agree. I think that you should be nationally certified through the NCRA or CBR to get that provisional license. And I think it's it's a good idea to have them maybe work as officials, so then the counties can work closely with them. I think it's easier than if they work for a bunch of different depot firms. And they can, I think that there should be some, maybe requirements. Each county needs to go over the minimum transcript formats, supply a handbook. Most counties have a manual that tells you what each transcript looks like. It has how many lines. They should be given include files, examples of transcripts. I do think the speed's there. The problem is the professional practice is probably not, and that's something they'll learn on the job. A lot of these test takers are having a hard time with the scenarios on the professional practice, so this will help them get to understand, oh, well, maybe I should do this there. I think the skill's there. I think that it's more they need to learn the hands-on part, and this is perfect for that. So yeah, as long as the county does their part and just doesn't throw them in there and say, here, make transcripts, guide them a little bit, give them, like I said, the handouts for all the court reporters that are given anyway, the minimum transcript format standards, just go over it with them and give them their includes and examples. I know clerks get paid, well, I don't know if every county's like this, but clerks get paid extra to train other clerks. Maybe that's something the courts can look into, is they take on this reporter, they go over their work with them, they get maybe paid extra, a few bucks more or something an hour to take on these provisional license reporters. I just think there's things that could be put in place to make it work. But yeah, I think the biggest hang up is that they haven't passed the professional practice. So working on this will help them get there, I believe. And let me make sure I didn't miss anything. I think that's it.
Thank you. Did we have anyone else from the public?
All right, looks like we do have a couple more individuals with raised hands, so I'm going to go in the, maybe just one. It looks like someone lowered their hand. So next we have Stephanie Whitehead, and Stephanie, you'll be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device. All right, and you are unmuted. This is the moderator. Stephanie, your microphone is unmuted now. You should be able to speak. Okay, let me try the request to unmute one more time and see if that helps. And Stephanie, this is the moderator. If you were speaking, we're unable to hear you. I'm going to put up some instructions on how to change your audio and see if maybe that helps. If not, I also have the Q&A box open if you want to type your comment and I can read it out loud. And while you are working on that, I'm going to go to our next individual who has public comment, and then I'll loop back around to you. So in the meantime, I have a public comment request from Ruby. In Ruby, you'll be given 3 minutes to speak and a 30-second warning. Please click the unmute me button when the prompt appears on your device.
Yes, I hope you can hear me.
Yes, we can hear you.
Okay. Just 2 off-the-wall comments. I'm a little off the wall. Maybe a provisional license to students who have passed 5 or 10 qualifiers. I've passed so many, I lost count, but I still have trouble with the online test. So that's something to think about, maybe if they pass 5 or 10 qualifiers. And the second off the wall comment is the test. I get it now. It's too expensive to give it in person. That's not realistic anymore. So maybe if you can give the test 1 out of 3 times, maybe at a school or a location that doesn't have to be a hotel and it's more cost effective. That's all. Thanks.
All right. And it looks like Stephanie has her audio switched. So Stephanie, I will request to unmute your microphone. Please click the unmute me button on your computer session when the prompt appears.
I apologize for that. Can you hear me now?
Yes, now we can hear you.
Okay, that's very strange. Thank you for hearing from me. And I wanted to say, again, on the provisional license, as many people have already said, I think the RPR, the CVR, or other states' licenses is a good idea for our provisional licensing. I'm wondering if a provisional licensee would have the same complaint procedures as a fully licensed reporter. Would you receive complaints and act on them in the same manner? The other thing that I wanted to say is I would urge the board, I strongly oppose Janet Harris's comments regarding AAERT certification. I mean, I think we're going through all of these machinations to avoid going to the digital recording and electronic recording in our courtrooms. So whether it's a digital monitor, that's not the gold standard. That's not what we're here to do. Thirdly, the first right of refusal to transcribe. I've been on the fence about this a long time. I know in federal court, the certified reporters have the first right of refusal to transcribe recorded proceedings. So again, I think it's something we could consider with the right safeguards in place. And then my final comment was to Ms. Brewer. I too am very passionate about the skills and how we got here, and we need to keep our standards high. But at the same time, I think our test should be an entry-level skill, and those skills can be developed over a lifetime of practicing. And I think every job has the potential to exceed our skills, and that's why we need to be bold and speak up to protect the record. And that's why, again, a licensee in the chair is going to be better than any digital recording, monitored or not. My last comment is a question, whether in going out to promote court reporting at schools or whether for in-person testing, has this Court Reporters Board asked for any state funds? It looks like the state is throwing money at this problem, but I'm wondering if they've offered anything to the Court Reporters Board to either promote or do the in-person testing. So that's all I had. Thank you.
Thank you.
All right, this is the moderator. Appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, please. I will say we've got a lot to consider. This, obviously, this topic's going to take further discussion, and I would suggest that we do that at our next meeting. And so we can move on to agenda item 5. I'm sorry, agenda item, oh, I skipped 2 regulations. Sorry.
Thank you, Chair Sunkis. I wanted to start off our regulations agenda item with a couple of introductions. First, I'd like to welcome Betsy Figuera to the CRB staff. Betsy has taken over as the manager of our regulations unit. She's working half-time as a retired annuitant. She's going to be with us for a 2-year limited term position.
She retired from the Contractor State License Board and actually has a bit of history with the Court Reporters Board in that many years ago, when we were allowed to hire workers in other state departments as consultants, she prepared regulations packages for us. So while she's busy learning our current issues, she doesn't have to start from scratch. We're very lucky to have her on board, as she's already helped us to develop a more complete regulations package for the voice writer curriculum, which you'll be reviewing shortly. And I just wanted to note that having a staff person dedicated to regulations is also going to allow us to catch up on the regulation packages that have been approved by the board but have not moved forward to OAL. So welcome, Betsy. And secondly, we have a new regulations attorney, Stephen Vong. Stephen's new to the Department of Consumer Affairs, but he's not new to regulations. I'll let him share a bit of his background and present the proposed language for the board's consideration today. Welcome, Stephen.
Good morning. Thanks, Yvonne, for the nice introduction. I have been with the state for 6 years, and I've been practicing law for over 6 years and did enforcement at the Department of Financial Protection and Innovation. So I'm a little bit familiar with consumer protection. And yeah, I can just read quickly about AB 156, which was introduced at the last board meeting. AB 156 allowed for the licensure of voice writers in California. The Voice Writers Task Force met to develop the curriculum for the skills portion of the prescribed course of study for approval by the full board. The proposed regulatory language was provided in the board agenda packet, again, starting on page 31. And I just, of course, want to say that I wasn't at the last board meeting. It's legal's position that although you did vote to approve the language on pages 38 and 41 regarding the strikeout of the word computer and the addition of the word device, device might be interpreted as vague under the Office of Administrative Law Standards for clarity and specificity. So if you did want to include device, legal would encourage you to have some kind of parenthetical explaining the potential types of devices that may include. Thank you.
Thank you.
The language of the proposed language is before the board. Betsy did, as I said, catch some things. So there are a few additions, but the motion, a proposed motion for the board's consideration, is on page 31.
Do we want to, I see a hand from Ms. Brewer. Do we want to open it up to public comment first, or actually let's move forward the way we've been doing it. So Ms. Brewer, your comments.
Please correct me if I'm jumping ahead with my comment, but I did have an amendment on page 37.1 where I think there was just a little mistake in editing this. The second to the last line, to match every other instance, it should actually be stenographic and or voice notes. The insertion was misplaced by a word. That's my only comment.
Which page, please?
Of our packet, it's page 37. At the very bottom, it's the penultimate line. Students own stenographic and or voice notes.
I see what you mean. The and or voice should be before the notes.
Correct.
Thank you.
Thank you.
Ms. Hurt, your hand is raised.
Yes, just going back to our Regulations Council comment about device not being, if I understood correctly, specific enough and could cause question from our court reporters on the board. Do they have any comments as to how that could be improved? especially as it relates to voice writers? And is there just one type of device? Are there many types? How expansive do we get into dangerous territory if we start listing every possible device when there's innovation that's happening constantly? So just curious.
Miss Brewer.
Well, I was the one who suggested device in the first place, so I guess this falls in my lap. I had hoped that this would be, a better phrasing, but if it causes problems, whatever works for the regulations, if we need to go back to computer. But, we could put a parenthetical in that says computer, iPad, monitor, but I take to heart what Vice Chair Hurt said, is that if we start spelling these things out, that really becomes a problem down the line because hardware changes. And that was my whole point from changing it from computer to device, is that hardware and viewing platforms have changed. So I'd like to see it be the most generic possible, but apparently that's in conflict with regulations, guidelines, or something. So I take umbrage.
Ms. Hurt?
Sorry, I meant to put my hand down. I would love to hear from you, Chair, if you had an opinion to this. And then I look to our council on whether digital device is sufficient, or, if that gets to being more specific enough. And I'll just end there. Thanks.
Along that line, the only thing I thought of was perhaps monitor device, or because that was my recollection, is we chose device to be all encompassing rather than specify all of it. And I see Miss I'm so sorry. Miss Joffrey, I see your hand raised. Sorry. Did you have some feedback?
I do. I am new to this board, and so I don't know that I was here when we were discussing it. And of course, I will defer to Regulation Council. But I'm wondering if a phrase similar to computer or similar device might be something effective.
Mr. Manayan?
Agree. Along those lines, I think we can, and I'll defer to council to help us with the exact verbiage, but either an electronic device or a computer electronic device or similar device or something to that effect, I think would be sufficient.
Ms. Hurd, I see your hand up. Is it? Okay. All right. So, Mr. Vong, did you have any other feedback?
Yes. The legals, the regulatory unit's position was just that the board needs to clarify whether it's referring to a desktop computer, tablet, laptop computer, or cell phone in parentheses. Otherwise, the Office of Administrative Law, OAL, will ask what devices are acceptable, or we need to include a definition for device in 2414 for universal application to these sections. So maybe just some kind of parentheses saying including but not limited to, or a computer, the word computer may already encompass that. But that's what our concern is, what OAL might interpret that might be.
Excuse me. And perhaps that's the way to handle it, is to insert the description, the further description. Limited.
Your choices are to come up with descriptors or leave it as computer.
Oh, I see. I see.
I'd like to make a suggestion based on council's input. The language could be outputting to a second device, electronic device, and in parentheses it can say including but not limited to a computer, a desktop computer, laptop computer, phone, tablet, and the like. I think that should be the catch-all that we need.
Does that
second
work?
If that's a motion, I'd second that. I like that.
That's a motion.
So first is it true that first we need to have a vote on the amendment to change to the language to electronic device, and then the description, limited, not limited to, but including the following, that verbiage, and then we'll go back and have the next vote. Is that correct?
Yes, it sounds like there was a motion and a second to adopt that language. And so I do believe there was a second. If there was a second,
yes,
I would also ask Regulations Council to confirm that this would indeed be an appropriate amendment. And if not, then the board can determine if they would like to continue regardless, or if they would like to fail the vote, or if we go forward with full support of Regulatory Council. But yes, we would need a vote on this motion now that it's been seconded.
Or it can be withdrawn.
Mr. Vaughn, do you have any opinions upon the proposed amendment to the regulations?
No opinion. Or I think we can confirm that if you accept my suggestion, the legal unit suggestions, and we can move forward.
Okay.
And it sounds like we have included that in the language. Ms. Hurt?
I have a question. Board Member Mayan, could you just repeat again your language so we can be all clear? I'll just say quickly, we've all talked about electronic recording and being very careful about how that's presented so that it doesn't open the gate to some of the concerns that we've heard here before about electronic recording only. So I'm a little bit shaky about using that language, but I'd like to hear exactly what you.
Sure. And feel free to modify as you deem appropriate. But the language that I am proposing is outputting to a second electronic device, including a computer, including but not limited to a computer, mobile phone, tablet, and the like.
So that could include a tape recorder? Including but not limited to.
Do you want to make?
Yeah.
Do we want to make sure that's excluded?
That's what I'm concerned about, and I would like to hear from either our executive director or maybe even the public if there's a concern that would be included by the language as it's stated. And I know this is a very, I wouldn't say controversial, but it is a very tricky area that I just don't want us to accidentally.
We need mobile phone. But Ms. Brewer?
Thank you. Yes, I feel like this is just getting needlessly complicated. And my whole purpose in the first place in offering device was to simplify and to make it less specific. And it sounds like the regulations want specificity. And so I'm just wondering if we shouldn't go back to computer. I mean, and I'd be interested in our council, our regulations council's advice on that. This wasn't meant to be unnecessarily complicated.
Sure. As Yvonne said previously, you can go back to just the word computer. Otherwise, we would have to be a little bit more specific. OAL might wonder what device might include, whether it's, as you stated before, some kind of voice recorder or something, or cell phone or tablet.
Ms. Tagade.
I wonder, given that our concern is around what is around the function of the device, I wonder if specifying, like rather than specifying which device, could we specify the function of the device or the program even? So saying a note-taking device or a note-taking program or like something to that effect, so that it's clear that we are not indicating any usage of the device, but specifically for that note-taking purpose.
Right. I will just say that I agree with Ms. Brewer that we should just go back to computer because we're talking about providing real time. And I see her hand, Ms. Hurt. I will call on you next. Going back to real time writing, we're writing and providing a live feed of what's being said. And so that's being provided on some type of computer device, on some type of computer. And I think that would handle it. Ms. Hurt.
So I was kind of merging the two and thinking maybe a conversation would be definitely bring back computer and or similar devices for note taking. So taking a little bit of, oh, I saw a head shake. Maybe that's not it, but I wanted to throw that out as an option.
Who was the head shake from?
Board Member Brewer.
Oh, okay. Ms. Brewer, your hand's raised.
Yes, and maybe, I hate to do this on the fly without reading the whole thing again and making sure about each point, but we're focusing here on the real time in the application of provision to counsel and the litigation setting. And so that could be interactive, but we're talking about display of the real time. So I think display rather than note taking is really a more appropriate narrowing. Display devices. But once again, I just, well, I've already said it, so I won't repeat myself. I wonder about going back to computer.
So we have a motion and a second. Are we going to do a substitute motion for this, or is there going to be a friendly amendment for Board Member Mayan?
Sure.
Or public comment.
Excuse me, Ms. Fenner, you had your hand raised?
I would just encourage the board to keep it simple.
And Ms. Degata, you had your hand raised.
Thank you, Chair. To the point of Ms. Brewer, is there a scenario in which, I understand we were wanting to be technology neutral, but I am trying to picture a scenario in which a court reporter might rely on another technology other than a computer, and trying to picture that scenario, even if it was a tablet, and perhaps one of our court reporters can speak to that.
Ms. Brewer.
In the instance of providing communication access real time or captioning, and this is done in the courtroom and also is done in litigation settings, it does not have to be a computer device. It can be on just a monitor, solely a monitor. And so since that's the type of work I was doing, that's what jumped out at me. But I don't think, I don't think that level of precision is necessary, and I didn't mean to create more of a problem.
What about computer monitor? Is that definitive enough, Mr. Vong? Computer monitor?
That limits it, Robin. Why can't we just leave it alone?
Just computer or device? I'm sorry, leave it alone.
Just go back to computer.
Okay. I'm fine with that. And then I interrupted Mr. Manayan when it sounded like he was going to perhaps amend his motion.
Yes.
Because I thought perhaps we'd have more fleshing out. So
I'll amend my motion to revert the language back to computer instead of device.
Is there a second?
As the initial seconder, I will take that amendment and second.
Okay. Now we have a motion by Mr. Manayan and a second by Ms. Brewer that the language should read to a second computer. Ms. Bruning, I'm sorry, apologize. I've said Ms. Brewer a lot this morning, sorry. Ms. Bruning, would you please take the vote?
May we please have public comment, Madam Chair?
Thank you very much
you.
for reminding me. Could we open it up to public comment?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Yes, please.
You ready for me now?
Yes, please.
Thank you. Ms. Brewer?
Aye.
Thank you, Ms. Hurt.
Aye.
Thank you, Mr. Manayan.
Aye.
Thank you, Ms. Tugade.
Aye.
Thank you, Ms. Sunkis.
Aye.
Thank you. Motion carries.
Now we will go back to does anyone have a motion on the amended, the whole packet, the amended packet, the way it's presented in the board book?
Do we need a separate vote on the correction that Ms. Brewer pointed out earlier? Or is that considered typographical?
And that question is for Mr. Vong or for Ms. Joffrey?
Either one.
And that just as a reminder, that is on the bottom of, was that 37? Yes.
Yes.
Page 37, second to last line of the page, and or voice, the highlighted portion should have been before the word notes.
I believe that question is for Mr. Vong.
To be safe, let's do it. Yes.
Okay. Do we have a motion on that?
I move approval of the edit by board member Brewer to shift and or voice on page 37 before notes, second line from the bottom.
Thank you. Do we have a second?
I'll second.
Thank you. We've got a motion by Ms. Hurt and a second by Ms. Brewer to move the words and or voice before the word notes on the bottom of page 37. Do we have any public comment on that motion?
This is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Yes, please. Ms. Bruning, would you take the vote, call for the vote, please?
Yes, thank you. Ms. Brewer?
Aye.
Thank you. Ms. Hurt?
Aye.
Thank you, Mr. Manayan.
Aye.
Thank you, Ms. Tugade.
Aye.
Thank you, Ms. Sunkis.
Aye.
Thank you. Motion carries.
Thank you. Do we have a motion on the packet as it's been amended?
Move approval.
Thank you. Do we have a second? Thank you, Ms.
Second.
Tagade. We have a motion by Ms. Hurt and a second by Ms. Tagade to approve the amended regulation packet. Could we ask for public comment?
All right, this is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close the Q&A panel?
Yes, please. And I will call Ms. Bruning to please call the roll on that vote.
Before you do that, Robin?
Yes.
Could I just clarify for that it's the board pleasure that they are, when they say so moved, that they're moving the language that appears on page 31, because there's a rescission of the last motion. There's additional language in that.
Oh, I see what you mean. When you say there's rescission of the last vote, you mean from the last meeting?
Correct. I want to make it clear for the record that Ms. Hurt's motion, it contains all of the language that appears on page 31.
Is that correct?
Yes.
Thank you. And that was the intent of the second as well, correct?
To move all the revisions, pages 32 through 41 that
So
are
there's specific,
highlighted and
there's specific language on 31. I'm sorry, Ms. Hurt, to interrupt you. Those are the elements that we need included in your motion. So I just want to make sure that when you say so moved, that's what you are referring to.
So I'll read it out. I'll recommend the board. I see the language for the recommendation, and that's the one that I'm following. So I move that the board rescind the prior proposed text approved December 14th, 2022, and approve the newly proposed regulatory text and changes to section 2403, 2411, and 2414 as provided in the materials, and direct staff to submit all approved texts to the Director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review. If no adverse comments are received, we authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for hearing if requested. If no adverse comments are received during the 45-day comment period and no hearing is requested, we authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulations at sections for sections 2403, 2411, and 2414 as noticed.
And amended.
And amended.
And Ms. Tagade, does your seconding the motion encompass what Ms. Hurt just recited?
Yes, thank you for that clarification.
Thank you. So with that, we have a motion by Ms. Hurt and a second by Ms. Tagade. I'm not going to repeat it, the whole motion. I believe we've already had public comment. Is that, Ms. Joffrey, do we need, since the motion has now been recited, do we need to open up for public comment again?
It's always a good time to ask for public comment. But I believe if we feel that we have sufficient public comment, then we may proceed because it all seemed to be on the same page. But I will never disagree with asking for public comment.
Okay. In an abundance of caution, would you like to open it? Would you please open it for public comment?
This is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close the Q&A panel?
Yes, please. Ms. Bruning, would you please call for the vote?
Yes, thank you. Ms. Brewer?
Aye.
Ms. Hurt?
Aye.
Mr. Manayan?
Aye.
Ms. Chagade?
Aye.
Ms. Sunkis?
Aye.
Motion carries.
Thank you. I too quickly want to welcome Ms. Figuere and Mr. Vong to the board. We'll look forward to working with you. And with that, I suggest that we take a lunch break. Is 30 minutes? I was anticipating 30 minutes. Will that be enough time for everyone?
Chair, could we possibly do 45 minutes?
Sure. If that's what we need, that's what we can take.
I would appreciate that. Thank you.
You bet. Okay, we'll see everyone in 45 minutes.